Alan Dershowitz has spent more than 50 years building a reputation as one of America's most prominent legal minds. The Harvard Law School professor emeritus became a household name through his involvement in high-profile cases, his prolific writing on constitutional law, and his frequent television appearances where he confidently explains legal principles to mass audiences. His credentials are formidable, his experience vast, and his willingness to engage in legal debate seemingly unlimited. When he speaks about constitutional law or criminal procedure, his words carry the weight of decades spent teaching, litigating, and commenting on the most important legal issues of our time. That made what happened during a televised debate on executive power and constitutional limits all the more extraordinary. Dershowitz had been invited to defend his controversial positions on presidential authority, positions he had articulated during recent impeachment proceedings, and that had drawn criticism from legal scholars across the political spectrum. Congresswoman Jasmine Crockett was invited to provide a contrasting perspective, representing lawmakers who believed that Dershowitz's theories of executive power threatened constitutional checks and balances. What followed was a legal debate so one-sided, so thoroughly dominated by Crockett's superior command of constitutional text and precedent, that law professors began using the clip in their classes as an example of how to systematically dismantle weak legal arguments. The debate lasted approximately 30 minutes, but the decisive moments came in rapid succession as Crockett methodically exposed the logical inconsistencies and textual problems in Dershowitz's positions. By the end, even the moderator seemed to recognize that this had been less a debate than a masterclass in constitutional argumentation, with Crockett in the role of professor and Dershowitz reduced to a student struggling to defend positions that crumbled under scrutiny. The legal community took immediate notice, and within days the clips were being shared in law school classrooms, faculty lounges, and legal commentary forums as evidence that even the most credentialed attorneys can be outmatched when their arguments lack constitutional foundation. Before we examine the specific legal arguments that Crockett deployed to dismantle Dershowitz's positions, analyze why her performance was so effective that it became required viewing in constitutional law courses, and explore what this debate revealed about the state of legal discourse in America, make sure to hit that like button and subscribe to stay informed about these important legal and constitutional developments. Now let us break down how Jasmine Crockett delivered a legal education that left Alan Dershowitz speechless and gave law professors everywhere a teaching tool they would use for years to come. Alan Dershowitz represents a particular type of legal celebrity that has become increasingly common in American public life. His academic credentials are genuine and impressive, including a long tenure at Harvard Law School where he taught criminal law and constitutional law to generations of students. His litigation experience includes representing high-profile clients in cases that attracted national attention, giving him practical courtroom experience to complement his theoretical knowledge. His media presence has made him one of the most recognizable legal commentators in America, someone producers call when they need expert analysis of complex legal issues. However, Dershowitz's recent trajectory had raised questions among legal scholars about whether his public positions reflected sound legal analysis or political advocacy dressed in legal language. His defense of expansive presidential power during recent controversies had struck many constitutional law experts as inconsistent with constitutional text, historical practice, and established precedent. His arguments seemed tailored to reach predetermined conclusions rather than following from neutral principles of constitutional interpretation. Critics suggested that his desire to remain relevant in political debates had compromised the intellectual rigor that should characterize legal scholarship. The specific positions that Dershowitz had articulated about executive authority were particularly controversial. He had argued that a president could not be charged with abuse of power if the president believed that his re-election was in the national interest, essentially claiming that almost any action taken to secure re-election was permissible. He had suggested that the constitutional standard for impeachment required criminal conduct and could not be based on abuse of power alone, despite historical evidence and constitutional texts suggesting otherwise. These positions had been widely criticized by legal scholars across the ideological spectrum as having no basis in constitutional law and as presenting dangerous implications for democratic accountability. Jasmine Crockett brought a very different perspective to the debate. Her legal education and her experience as a practicing attorney had given her solid grounding in constitutional law and criminal procedure. Unlike Dershowitz, whose recent public statements seemed driven by political considerations, Crockett's legal arguments were grounded in constitutional text, founding-era documents, and Supreme Court precedent. She approached legal questions with the mindset of someone who had to make arguments that would persuade judges based on law rather than someone trying to persuade television audiences based on political sympathies. The stakes of this debate extended beyond the immediate question of executive power. At issue was whether legal expertise and credentials automatically translated to correct legal arguments, or whether the substance of legal reasoning mattered more than the reputation of the person making the argument. The debate would test whether someone with Dershowitz's name recognition and academic pedigree could prevail simply through assertion and authority, or whether careful legal analysis grounded in constitutional text and precedent would prove more persuasive. For the Legal Academy, the debate represented an opportunity to evaluate competing approaches to constitutional interpretation in real time. Law professors who would later use clips from this debate in their teaching were interested not just in who won the argument but in how the argument was conducted, what sources were cited, how counterarguments were addressed, and whether the reasoning was consistent and principled. The debate would provide a case study in legal argumentation that could be analyzed for pedagogical purposes. The television format added another dimension to the stakes. Unlike academic seminars where arguments can be developed at length with extensive citation to sources, televised debates require concise communication that reaches general audiences without sacrificing legal accuracy. The challenge for both participants was to make sophisticated legal arguments accessible to viewers who might not have legal training while maintaining the intellectual rigor necessary to persuade legal experts who would be watching and evaluating their performance. The debate began with each participant providing opening statements outlining their positions on executive power and constitutional limits. Dershowitz went first, speaking with the confidence and polish of someone who had given similar presentations many times before. He argued that the Constitution gave the president broad executive authority that should not be lightly constrained by Congress or the courts. He suggested that aggressive congressional oversight represented a dangerous encroachment on executive prerogatives, and that recent impeachment efforts had stretched constitutional standards beyond recognition. Dershowitz relied heavily on his reputation and experience, frequently referencing his decades of teaching constitutional law and his involvement in previous cases touching on executive authority. He spoke with absolute certainty, presenting his controversial positions as if they represented settled law rather than novel theories that had been widely rejected by constitutional scholars. He used hypotheticals and rhetorical flourishes designed to make his positions seem more reasonable than they appeared when subjected to textual analysis. Crockett's opening statement took a markedly different approach. Rather than relying on credentials or reputation, she began by reading directly from constitutional text. She quoted the specific provisions establishing congressional power to impeach and remove executive officials, noting that the Constitution provided no requirement that impeachable offenses be criminal in nature. She cited Federalist Papers passages discussing the founders' concerns about executive abuse of power, and their intention that impeachment serve as a remedy for political crimes against the state. She referenced historical impeachments that had been based on non-criminal conduct, demonstrating that actual constitutional practice contradicted Dershowitz's claims about impeachment standards. The moderator then posed the first question, asking Dershowitz to explain his position that a president could not be charged with abuse of power if the president believed his actions were in the national interest. Dershowitz responded by defending his position as simply recognizing political reality, arguing that presidents inevitably act with consideration of their political interests and that attempting to impeach them for such consideration would make every president impeachable. He suggested that his position simply acknowledged what everyone already understood about political motivation. Crockett immediately challenged this response. She noted that Dershowitz had shifted his argument from a legal claim to a practical observation. She pointed out that the question was not whether presidents consider political factors, but whether the Constitution permits impeachment when a president abuses official power for personal political gain. She quoted James Madison from the Constitutional Convention discussing the impeachment power as a remedy for executive attempts to corrupt elections or betray the public trust. She noted that the founders explicitly included abuse of power as grounds for impeachment, regardless of whether such abuse also constituted a criminal violation. Dershowitz attempted to counter by arguing that the constitutional term high crimes and misdemeanors had a technical meaning that required criminal conduct. Crockett was ready with a comprehensive response that demonstrated superior command of the historical record. She explained that high crimes and misdemeanors was a term of art from English parliamentary practice referring to political offenses by public officials, not criminal violations. She cited specific examples from English history where officials had been impeached for non-criminal conduct. She quoted founding-era statements from multiple Constitutional Convention delegates making clear that impeachment was intended to reach non-criminal abuses of power. The exchange was becoming increasingly one-sided. Dershowitz's responses grew more defensive and less confident, as Crockett systematically demolished each of his arguments with specific textual and historical evidence. When he tried to cite Supreme Court precedent for his positions, Crockett pointed out that he was mischaracterizing the holdings of the cases he referenced. When he attempted to use hypotheticals to make his arguments seem more reasonable, she demonstrated how his hypotheticals were not analogous to the actual situations being discussed. A particularly devastating moment came when Dershowitz tried to argue that impeaching a president for abuse of power would mean that any policy disagreement could become grounds for impeachment. Crockett responded by noting that this was a classic slippery slope fallacy that ignored the specific constitutional standard. She explained that abuse of power referred to using official authority for personal gain or to corrupt democratic processes, not to policy choices that Congress disagreed with. She noted that Dershowitz's argument assumed that no meaningful distinction could be drawn between legitimate exercises of executive authority and corrupt abuses of that authority, which made no sense as a matter of constitutional design. Dershowitz then attempted to shift ground by arguing that whatever the historical evidence, the practical implications of Crockett's position would be dangerous for executive authority and governmental functioning. This line of argument represented an implicit concession that he could not win on constitutional text or historical practice. Crockett seized on this shift, noting that Dershowitz was now abandoning legal argument in favor of policy preferences. She pointed out that the Constitution established specific limits on executive power precisely because the founders understood the dangers of unchecked executive authority. She said that arguing for weaker constitutional constraints because stronger constraints might be inconvenient was backwards reasoning that put policy preferences ahead of constitutional command. Throughout these exchanges, the contrast in argumentative approaches was striking. Dershowitz relied on assertion, reputation, and rhetorical maneuvering. When pressed for specific constitutional support for his positions, he either cited sources that did not actually support his claims or fell back on pragmatic arguments about the consequences of alternative interpretations. Crockett grounded every argument in constitutional text, historical evidence, or established precedent. She anticipated counterarguments and addressed them preemptively. She remained focused on legal analysis rather than personal attacks or political considerations. The moderator, recognizing that the debate was becoming an intellectual mismatch, tried to help Dershowitz by asking questions that might give him firmer ground. But even these attempts failed because Crockett had command of the relevant law and Dershowitz did not. When asked about historical examples of presidential actions that might have constituted impeachable abuses of power, Dershowitz struggled to distinguish genuinely corrupt conduct from legitimate exercises of authority. Crockett provided specific examples with clear explanations of why particular actions crossed constitutional lines, demonstrating that principled distinctions could be drawn. The decisive moment of the debate came when Dershowitz attempted one final argument that he apparently believed would be compelling. He suggested that Crockett's interpretation of executive power would make it impossible for presidents to govern effectively because they would constantly face threats of impeachment from political opponents. He painted a picture of endless political warfare if Congress could impeach presidents for abuse of power without requiring proof of criminal conduct. Crockett's response to this argument demonstrated why law professors would later use this clip as a teaching tool. She began by noting that Dershowitz's argument assumed that presidents needed the ability to abuse their power in order to govern effectively, which was an extraordinary and troubling claim. She pointed out that the vast majority of presidential actions involved legitimate exercises of constitutional authority and would never be subject to impeachment proceedings. The impeachment power existed precisely for those rare situations where a president violated the public trust in ways that threatened the constitutional order. She then walked through the specific constitutional safeguards against frivolous impeachment. She noted that impeachment required a majority vote in the House of Representatives, representing multiple districts and diverse constituencies. Removal required a two-thirds vote in the Senate, an extraordinarily high bar that ensured that only genuinely serious misconduct would result in removal from office. She explained that these procedural requirements meant that impeachment functioned as intended, available as a remedy for serious abuse but practically difficult to accomplish without broad consensus about wrongdoing. Crockett then addressed the historical record directly. She noted that despite the availability of impeachment throughout American history, it had been used sparingly and only in situations of genuine constitutional crisis or serious misconduct. She pointed out that the existence of the impeachment power had not prevented presidents from governing effectively or from exercising robust executive authority within constitutional bounds. The empirical evidence contradicted Dershowitz's claim that robust impeachment standards would paralyze the executive branch. She concluded this portion of her argument by turning Dershowitz's concern on its head. She noted that his interpretation, which would effectively immunize presidents from accountability for abuse of power, created far greater dangers than the problems he warned about. If presidents could act corruptly without fear of impeachment as long as they believed their actions served their political interests, the constitutional system of checks and balances would be meaningless. The founders designed the Constitution precisely to prevent the kind of unchecked executive power that Dershowitz's theories would enable. Dershowitz had no effective response. He attempted to suggest that Crockett was mischaracterizing his position, but she immediately quoted his own previous statements supporting the characterization she had provided. He tried to argue that his position was more nuanced than she was acknowledging, but she demonstrated that the nuances he now claimed had not appeared in his public advocacy and seemed to be additions designed to make his position more defensible after the fact. The moderator then opened the floor to questions from a panel of journalists and legal experts who had been observing the debate. The questions largely focused on asking Dershowitz to defend specific aspects of his argument that Crockett had challenged. His answers were notably less confident than his opening statement had been. He frequently qualified his positions in ways that seemed to contradict his earlier categorical statements. He admitted that some of the constitutional and historical evidence Crockett had cited was accurate, though he tried to minimize its significance. One particularly revealing exchange occurred when a law professor on the panel asked Dershowitz whether he could cite any constitutional law scholars who agreed with his interpretation of impeachment standards. Dershowitz mentioned a few names but had to acknowledge that the vast majority of constitutional law experts, including many conservatives, had rejected his position. The questioner then asked Crockett the same question, and she was able to cite numerous scholars across the political spectrum who agreed that abuse of power could constitute grounds for impeachment without requiring criminal conduct. The contrast made clear which position had actual support in the legal academy. Another powerful moment came when Crockett was asked how she had developed her expertise on these constitutional questions. Her answer highlighted the difference between genuine legal analysis and political advocacy dressed as legal argument. She explained that as a practicing attorney, she had learned that making legal arguments required grounding them in constitutional text, precedent, and historical practice. She noted that judges did not accept arguments based solely on the advocate's credentials or on policy preferences about desirable outcomes. She said that her approach to this debate was the same approach she would use in any legal proceeding, starting with the relevant text and following the analysis wherever it led rather than beginning with a desired conclusion and working backward to find supporting arguments. Dershowitz was given an opportunity to respond, but his answer revealed the weakness of his position. He defended his approach as reflecting decades of experience and comprehensive understanding of constitutional principles. However, he could not explain why his comprehensive understanding led him to conclusions that contradicted constitutional text, historical evidence, and the consensus view of legal scholars. His appeal to experience rang hollow when his actual arguments lacked the foundations that legal analysis requires. As the debate drew to a close, the moderator attempted to summarize the key points of disagreement. However, the summary revealed that this had not been a debate between equally valid interpretive approaches, but rather a demonstration of the difference between rigorous legal analysis and unsupported assertion. Crockett had grounded every argument in specific constitutional provisions, historical evidence, and established precedent. Dershowitz had relied primarily on assertion, selective quotation, and policy arguments that contradicted constitutional design. The asymmetry was obvious to any viewer with legal training. The reaction from the legal academy was swift and remarkably uniform. Constitutional law professors across the country began sharing clips from the debate, praising Crockett's performance as an exemplar of effective legal argumentation. Within days, syllabi were being updated to include the debate as required viewing, and class discussions were being structured around analyzing why Crockett's arguments were so much more persuasive than Dershowitz's despite his superior name recognition and credentials. Law professors identified several specific aspects of Crockett's performance that made it valuable for teaching purposes. Her systematic approach to legal argumentation, beginning with constitutional text and building through historical evidence to practical application, demonstrated the proper structure for constitutional analysis. Her anticipation and preemptive addressing of counterarguments showed students how to strengthen their own arguments by considering objections. Her use of specific citations and quotations rather than vague references to authority illustrated the importance of precise evidence in legal reasoning. Her ability to distinguish between legal arguments and policy preferences showed students how to maintain analytical rigor even on politically charged questions. The debate also became a case study in how not to argue legal questions. Professors used Dershowitz's performance to illustrate common errors in legal reasoning, including begging the question by assuming conclusions that needed to be proved, mischaracterizing precedent to support desired outcomes, shifting ground when initial arguments failed, and substituting reputation for reasoning. Students learned to recognize these argumentative failures in their own work and in the legal arguments they would encounter in practice. Media coverage of the debate focused heavily on the mismatch between the participants' reputations coming in and their actual performances. Dershowitz had entered the debate as the presumed expert, with decades of experience and academic credentials that seemed to give him natural advantages. Crockett was less well known in legal circles at that point, and some observers had expected her to be overmatched. The reality proved the opposite, demonstrating that credentials matter less than the quality of legal reasoning and that reputation cannot substitute for sound constitutional analysis. For Alan Dershowitz personally, the debate represented a significant professional setback. His performance had exposed the weaknesses in positions he had been advocating publicly, and his inability to effectively defend those positions against someone with superior command of constitutional law damaged his credibility. Legal scholars who had previously viewed him as a serious constitutional thinker began treating his public pronouncements with greater skepticism. His future television appearances were met with more critical questioning as producers recognized that his conclusions might not reflect mainstream legal thinking. The debate also affected ongoing political controversies about executive power and accountability. Crockett's systematic dismantling of arguments for expansive executive authority strengthened the constitutional case for robust congressional oversight and meaningful impeachment standards. Lawmakers who had been uncertain about the legal foundations for holding presidents accountable found clearer articulation of the constitutional principles at stake. The debate shifted the terms of discussion from whether Congress had authority to check executive abuse to how that authority should be exercised in specific circumstances. For Jasmine Crockett, the debate confirmed her emergence as a serious voice on constitutional law. Legal organizations began inviting her to speak at conferences and symposia. Law schools invited her to participate in panel discussions and guest lectures. Her demonstrated expertise made her valuable to democratic leadership on legal and constitutional matters. The debate served as evidence that she was not simply an effective political communicator, but someone with genuine legal expertise that could be deployed in high-stakes constitutional debates. The broader implications for legal discourse were significant. The debate demonstrated that the most important legal conversations could and should be accessible to general audiences without sacrificing intellectual rigor. Crockett had made sophisticated constitutional arguments in language that non-lawyers could follow, proving that legal complexity does not require jargon or obscurity. This accessibility made the debate valuable not just for law students, but for engaged citizens trying to understand constitutional principles that affect democratic governance. Academic commentary on the debate highlighted several broader themes about the state of legal argumentation in public discourse. Scholars noted that political polarization had led some legal advocates to prioritize reaching desired political outcomes over maintaining analytical rigor. Dershowitz's performance illustrated the dangers of this approach, showing how abandoning neutral principles of legal interpretation in service of political goals undermines credibility and produces legally unsound arguments. Crockett's performance demonstrated that it was possible to have clear political values while still maintaining analytical rigor and intellectual honesty in legal reasoning. The debate also sparked discussions about the role of legal expertise in democratic decision-making. Some defenders of Dershowitz suggested that criticizing a Harvard law professor's constitutional arguments was inappropriate or reflected anti-intellectual bias. However, other scholars pointed out that expertise deserves respect only when it produces sound reasoning grounded in relevant sources. They noted that expertise can be misused to legitimate unsound arguments through appeals to authority, and that democratic discourse requires the ability to evaluate legal arguments on their merits rather than simply deferring to credentials. Law schools used the debate to reinforce lessons about legal ethics and professional responsibility. Professors noted that lawyers have obligations to provide sound legal advice, even when such advice might not serve immediate client interests or personal political preferences. Dershowitz's apparent tailoring of legal arguments to reach politically desired outcomes violated this professional obligation and illustrated the reputational costs of prioritizing advocacy over honesty. Students learned that short-term advantages gained through unsound legal arguments could result in long-term damage to professional credibility. The debate became a reference point in subsequent legal controversies. When other attorneys or commentators made arguments about executive power or constitutional limits, their positions were compared to the Dershowitz-Crockett debate. Arguments that resembled Dershowitz's approach were criticized as legally unsound regardless of who made them. Arguments that followed Crockett's methodology of grounding claims in constitutional text and historical practice were treated as more credible. The debate established a standard for constitutional argumentation that continued to influence legal discourse long after the specific political controversies that prompted it had faded. For legal education more broadly, the debate reinforced several pedagogical principles. It demonstrated the importance of teaching students not just legal rules but the methodology of legal reasoning. It illustrated the value of close attention to constitutional text rather than relying on vague principles or policy preferences. It showed students that effective advocacy requires anticipating and addressing counterarguments rather than simply asserting conclusions. These lessons appear in every first-year constitutional law course, but the debate provided a concrete example that made them more vivid and memorable. The lasting impact of the debate can be measured in part by how frequently it continues to appear in legal education. Years after the debate occurred, law professors still assign it as required viewing. Legal writing instructors use transcripts of the debate to teach argumentation technique. Constitutional law scholars reference it in academic articles discussing executive power and impeachment standards. The debate achieved a kind of canonical status, joining a small group of legal exchanges that are considered essential viewing for understanding constitutional law and legal reasoning. If you want to continue learning about how constitutional law shapes American governance and how legal experts evaluate arguments about executive power and democratic accountability, make sure to like this video and subscribe to the channel. The debate between Jasmine Crockett and Alan Dershowitz represents more than just one political moment. It provides a template for how constitutional arguments should be constructed and evaluated. It demonstrates that credentials and reputation matter less than the quality of legal reasoning. It shows that careful attention to constitutional text, historical evidence, and established precedent produces more persuasive arguments than reliance on assertion and selective quotation. These lessons remain relevant for anyone trying to understand constitutional law or evaluate legal arguments in public discourse. Law professors will continue showing this clip because it teaches essential lessons about legal reasoning that every law student needs to learn. Thank you for watching, and we will continue to provide analysis of the legal debates that shape our constitutional system.